Hey everyone, Stephen Kelly here from Kelly Clark. Hope all of you are well. We have friends and family that are scattered around the country right now. We know that everybody is concerned about what's going on, and we're trying to be a resource to clients, potential clients, friends and family alike that are concerned about their agreements, the written agreements that they have, either with their properties or just in general. So today, hope this video is helpful for you. Like the last video and all of our videos, your situation may be different than the general legal concepts that we're talking about. So I encourage you that if you have further questions that are fact specific to your situation, that you reach out and talk to your lawyer about those. If we're your lawyer, then call us, email us, and we'll be happy to schedule a time that we can help you. We want to be a resource to you during this time. So today we're talking about impracticability. So many of you that have existing contracts in the commercial real estate space may have an existing express provision in your purchase and sale agreements, like a force majeure clause or something like that. That's not what we're talking about. We're talking about contracts that where you may not have a clause at all. And many of you have thought, well, then if I don't have a clause at all, then am I out of luck? And the answer is no. There are legal doctrines out there that provide relief, both to buyers and sellers alike, that will help them either cancel a contract or provide some sort of measure of relief. Today, we're going to talk about impracticability. Sometimes people call this impossibility, and the definition of this, we find this in what we call the Restatement Second of Contracts, which is just the broad treatise area of law that all of us that are practitioners in the practice of law kind of go to as a baseline for understanding certain of these types of concepts. Here, impracticability can be defined basically as where after a contract is made, a party's performance is made impracticable with his or her fault by the occurrence of an event. When we say his or her fault, meaning we can't perform. We will not be able to purchase the apartment building. We will not be able to complete our acquisition. Why? Because there was an event or a non-event, a non-occurrence, meaning the presence of the pandemic, right? Or COVID-19, or some other triggering event like a war or a recession or depression. Those types of non-foreseeable events may serve as a trigger for this doctrine of impracticability. And we see that if there is a triggering event, that his or her duty, meaning our duty if we're the buyer or the seller, to render the performance, meaning to either complete the acquisition or to do something, is discharged, meaning it's waived. It's not, we don't have to complete it. We don't have to complete that task unless the language, meaning unless our contract is contrary to that, or the circumstances indicate the contrary. So what are the elements really of this doctrine of impracticability? Remember, these are general, this doctrine is generally sought to be enforced in a contractual setting. You may or may not have a written force majeure clause, but what are the elements? Well, was there an unforeseen event or occurrence? So let's just take COVID-19. Obviously, this was, by any measure of stretch of the imagination, this was an unforeseen event. This is a global event. Nobody could have foreseen that this was actually going to occur. The second prong, is the reason unforeseeable, meaning entering into a contract, did you know that there was going to be COVID-19 that might prevent you from completing your acquisition? Either that you wouldn't be able to find debt or be able to inspect the property, or your lender to be able to do phase one testing, or all of those various things that may be fact specific for your situation But the concept that I want you to grasp is the reason for your wanting to get out of the contract, was it foreseeable? Meaning, did you know that it was coming? Is it reasonable to think that it would be coming? And the answer for this pandemic, in my opinion, is no, absolutely not. It was not a foreseeable thing. And the third one is the occurrence must make performance difficult or impossible. That's obviously one of the most challenging prongs, because your performance will not be discharged, right? Meaning you will not be able to cancel your contract under the doctrine of impracticability if you caused it. Meaning if you were the source I mean, it doesn't really apply with COVID-19, but if you were the person creating the situation that caused the impracticability, you will not be able to cancel your contract. Two, that you knew about this or you had reason to foresee, right? Again, that's that we won't be able to cancel the contract as pursuant to this legal doctrine. Or three, language or the circumstances indicate the contrary. And in some states, in some cases, have drawn distinctions between impracticability that is subjective versus impracticability that is objective. What I want you to understand here is that depending on the state in which you live in, or the circumstances that you have, there have been courts that have looked at this and said there is a difference between I cannot do it or the thing cannot be done, right? You see the difference. One is subjective and one is objective. Consequently, where the promisor, meaning somebody that enters into the contract, one of the parties, agrees to perform an act possible in itself, he will be liable for a breach of the contract, even though contingencies not foreseen by him or her arise that make it difficult or even beyond their power to perform, and which might have been provided again in the agreement. So profitability, right? Or it's not as profitable now. Some of those arguments will fall flat, meaning those cannot serve as the basis for the impracticability defense. But inability to see the property because the tenants will not let you have access to perform your physical inspections. The capital markets are frozen. Inability to obtain debt in connection with the acquisition, which is impliedly in many of these purchase and sale agreements, the lender or the amorphous lender is listed in these contracts, meaning there is an expectation by both seller and buyer that there will be some debt component to these transactions if the pandemic makes that situation impracticable, such that by any objective measure you can't perform. This legal doctrine is important and potentially applicable. So I hope that this was helpful for you. We're going to continue to do this because it's helpful for our clients. We receive great feedback. If you have any questions in connection with this video or other videos that come out from us, feel free to ask those questions. You can always follow us on Instagram or Facebook. There's our contact information. Be safe, everyone. Be well. Talk to you soon. Thanks.